This is WAAY 31 Law Call.
Good evening and welcome to WAAY 31 Law Call. I'm Sharon Doviet. Tonight we're taking your calls and questions on any legal topic. It's Ask Us Anything night, so call in whether you've got questions about a car accident, maybe you've got questions about a product that has hurt you, maybe you've got concerns about a loved one that's in nursing home care and you think maybe they're not getting the best care. What do you do about that? Or if you've got questions about child support, anything, we will either answer the question or point you in the right direction to get help. Call in the 31 Law Call number 536-0077. You can also email a question. You can email any legal question any day of the week. Send it to lawcall@waaytv.com. And when we get to a show that's on point, we'll pull some out. We'll have some of your email questions tonight. We've got with us Michael Timberlake from Timberlake & Leak. Good to have you here.
It's great to be here.
We're talking, well, it's Ask Us Anything night.
Here we go.
So here we go. We like to start off with a video. We pulled some video off of YouTube, and it's your chance. You make the law call. In this case, it's a rear-end accident. You guys do tons of these. You see it coming. And with so many cars having video cameras these days, you see a lot of them. But is it a rule across the board that whoever is in front, they're in the right? So the person behind ought to be able to stop. Is that the way the law looks at it, or what does it take to make the guy in front in trouble?
Well, I mean, basically there are certain rules of the road that require certain safe distances between you and a vehicle in front of you. But in this case, clearly this vehicle came from an adjacent roadway into the path of the right-of-way for the other vehicle. So that's going to be a situation where it's going to be this other vehicle's fault, the one that pulled out, regardless of whether it was a rear-end collision or not. What's fascinating is that we do see a lot more of these video camera type things, and it's just absolutely great because you can tell really what happened as opposed to trying to piece things together from witnesses. Witnesses do the best thing they can to try to remember what happens and specify what happens, but a lot of times it gets lost in translation. So having a video that you can introduce in court is really compelling.
Have you put cameras on your car?
I haven't yet, but I am thinking about it real hard.
It does make you think. And an accident, even something as simple as that, with today's cars, that's thousands and thousands of dollars in damage, right?
Sure.
Yeah.
And at the end of the day, the driver that pulled out could say, I was just driving down the road and they hit me, and there's only, it's a he said, she said, and it's hard to win those in court.
Yep. Okay, call in if you've got questions to the night, the 31 Law Call number 536-0077. We've got a caller. Howie is on the line with a question from Huntsville. Hi, Howie, thanks for calling. What's your question tonight?
Yeah, hi. I purchased at a clerk sale someone's interest in their share in a probated estate of a house that their parents owned, and can't find that person, but another one of the inheritors apparently is his sister, and she's claiming that since we can't find that person and they have no children, that she is actually an heir of her brother, and therefore, according to Alabama law, she claims that she can redeem the property from the clerk's sale. And I want to find out if since the other person hasn't died, or we don't know he's died, is that correct?
That's a pretty detailed question. If the person is, if there's not, confirming evidence that he is deceased or confirming evidence that he's no longer with us, I don't think there's any way that she could be the sole owner of that property. It would be jointly owned between the two of them. She could file, an action to quiet title to try to, and if she can't serve him by publication, then, then she could potentially be declared to be the owner. But just the fact that we don't know where he is not enough to get her to be the sole beneficiary of the property.
What do you think? He needs a probate lawyer, or he needs a real estate lawyer?
Real estate lawyer would be what I would look for, somebody that handles that type of thing.
Good luck with it, Howie. I was at a Christmas party tonight. We were playing Dirty Santa, and friends are asking, they know we do the show tonight, and I don't know if it was Francie or Christy that was asking, okay, if my Dirty Santa gift winds up hurting me, who do I sue? Okay, hopefully none of the presents tonight are going to hurt anybody. But if you give someone a gift and they get hurt with it, are you liable to get sued? Are you responsible?
Your friends should absolutely sue you if you buy them a gift that they get hurt. You should sue them out of principle.
It ends the friendship.
I'm kidding. It's a situation where you look at what are the facts and circumstances that occurred. Was the product that they were used in the way that it was intended to be used? Was their product misuse? Is the manufacturer liable? In Alabama, there's Alabama's extended manufacturer's liability doctrine, which basically says if the person who manufactured the product knew or should have known that this product was defective in some way, that it was going to malfunction, then they can be held responsible for injuries that occur.
Okay. We've got Wanda on the line with a question from Newmarket. Hi, Wanda. Thanks for calling. What's your question tonight?
Yes, my dad died 8 years ago today.
I'm sorry.
And he left his wife a life estate, and he left his daughters, me and my sister, everything once she's gone.
Okay.
And so my question is, her daughter moved in with her like 6 or 7 years ago, and once she passes, which we don't wish that upon her, what do we do about her daughter living in the home?
Gotcha.
Right. So basically, what would happen is once she passes away, her life estate in the property, her interest in the property ends. At that point, you become the owners of the property. You can, probably the best thing to do would be talk to an attorney, but you can basically by affidavit, file an affidavit, you can assume, the property and have it, titled in your name at that point. If there is somebody that is a tenant in the property or somebody that is that has lived on the property legally, you're just going to have to, and they won't leave voluntarily. You'd have to, serve them a notice of eviction in accordance with the law, have them served with the eviction notice, and then have them moved off the property. Hope that wouldn't be the case, but once you become the owner, you have the right to evict somebody, but you have to go through the process.
Good luck with it, Wanda. Okay, let's talk about, a lot of people are traveling this time of year.
Absolutely.
If they're traveling and they have an accident, say, we'll assume they're driving. You have an accident in another state, but you're from Alabama and you come back home to Alabama. Where is that case going to be? Can you handle it from here? Do you need a lawyer from here? Talk to people about what might happen with something like that.
Yeah, I mean, typically, if you're dealing with a situation where there's an incident occurs in one state, more than likely you're going to be pursuing an action in the state where the wreck occurred. It can be that if there's two people from different states and there are no strong connections to the area where the accident occurred, you could potentially pursue a claim in federal court in the other state where the other person resides, or in a state where you reside, if it's a different state from where the accident occurred. So you look at a lot of different options in that situation, but most likely it's going to be legal action is going to be pursued where the accident occurred.
And most car accident cases wind up settled, right?
About 80% of them do.
Unlikely you're going to have a trial in another state.
Yeah.
Could happen.
I mean, what we look at it in terms of, interstate litigation, a lot of it deals with commercial vehicles or commercial conduct. Or, is it a situation where this is a company that's better to sue them out of another state than it would be here? Or a situation where it's more convenient to your people to sue in another state.
Gotcha. We've got Fernando on the line with a question from Athens. Hi, Fernando. Thanks for calling. What's your question tonight?
Hey, how's it going?
Hi,
good. Man, how are you?
Thanks for calling.
No problem. So I recently won a default judgment in federal court. I had several claims. I had a sexual harassment, wrongful termination, retaliation, and sexual harassment, wrongful termination, retaliation, and racial discrimination.
Okay.
So my lawyer, my lawyer decided not to go after the money, and I'm kind of confused about this because during the deposition, the defendant, he admitted to getting a check back from the insurance, which he did not put into the LLC to pretty much cover the claim. He put it into his pocket. My lawyer never went after that. And also, there was the sexual harassment claim. I was looking online, and me and my girlfriend was doing research, and we so happened to find that the claim was about to be kicked out due to lack of evidence. My lawyer never told me this.
Okay.
And when I addressed this, she pretended to put the appeal in, but when I went to court to the clerks, there's no appeal that was ever filed. Is this an ethics violation?
Okay, you got a lot going on.
Yeah, I mean, you got a lot going on there. You know, let's start with, kind of the first thing. Why would a lawyer not, continue to try to pursue a default verdict? If you've got a judgment against somebody and there's not an insurance company that's behind them that will pay the judgment, then you're looking at having to try to collect from that individual LLC or the individual. That can be problematic, time-consuming, and a lot of times you're just beating your head against the wall, running kind of down a dead end. Lawyers, obviously want to be paid for the effort that they put into a case, but putting more time and effort for the possibility of getting paid with the likelihood of not getting paid is something that a lot of lawyers, wouldn't look into. But in a situation where you do have a judgment, you can talk with, a lawyer that does collections work, and they're a little more set up than a lot of lawyers to try to go after people to try to get private assets or private funds. So that's, the effort that I would look into in that situation. As far as, whether the money that the insurance company paid was available to you or to your lawyer, I would assume that if there was some funds there that were readily available, any lawyer would look into that immediately. If those funds get commingled with other funds, they can be very difficult to identify and get in that situation. So collection work, it's kind of tough, but it's, that there are lawyers that do that and do a very good job with it.
So he could take his judgment and go find a different lawyer and they could collect it for him.
Sure.
Good
And, and in terms of, what your lawyer did or didn't do, it's really a case-by-case situation. I'd have to look at it. But clearly, if a motion's filed to dismiss your case, that's a serious thing. And, that's one of the things that you need to talk to your client about. You need to tell your clients everything that's going on in their case.
We're going to take a break. Be right back. If you're on the line, stay on the line. We'll be right back answering your questions. It's Ask Us Anything night tonight.
You're watching WAAY 31 Law Call, where lawyers come to help. Your rights, your calls, live. Hosted by family law attorney Sharon Dovian. With the personal injury attorneys of one of the Valley's most respected law firms, Timberlake and League. Featuring the knowledge of managing partner Michael Timberlake, with millions of dollars awarded to his clients. And the experience of attorney Will League, a strong courtroom fighter known for his commitment to winning. And the fellow partners of Timberlake and League Heath Brooks and William Meservey. This is WAAY 31 Law Call.
Welcome back to 31 Law Call. I'm Sharon Doviat. Michael Timberlake's here from Timberlake and League answering questions, and it's Ask Us Anything night, and we've got callers waiting. Teresa has waited. Thank you, Teresa, for waiting from New Hope. What's your question tonight?
Hi, thank you for taking my call.
Sure.
My question to you is, can an ambulance deny service? My dad is 85 years old. He currently lives with me. He has recurring UTIs, and there's a home service that would come in, and their purpose to come in was to keep him out of the hospital. I had told them on day one, he has a UTI, he needs antibiotics, he's starting to talk out of his head. They said he looks fine, his vitals are fine. 2 days later, it's got worse. My dad does not even know where he is. I called an ambulance, and I also called that service. The ambulance came. My dad gave him his name, birthday, and said he did not want to go to the hospital. Well, of course, he's going to say that because he does not know where he is. And I've been trying to, and I'm sitting here with 2 different types of power of attorney and crying and saying my dad is very, very sick and he needs to go to the hospital. They refused, said it would be kidnapping. Well, the next day they finally called, and he was pretty much incoherent, not responding, but they did take him the next night after I got rid of this one home service.
Okay.
But they were saying it was not because of the home service, it was because it was kidnapping. Okay. And so can they actually deny taking someone to the emergency room when you've got someone that is their caretaker, letting them know that they are in dire need to be at the hospital.
Yeah. And yet he's making good sense when they're there.
Right. You know, it kind of comes down to, you know, it's more of like a probate matter. It's, you know, okay, what is his level of competency? Is he competent? Can he make decisions for himself? Is he lucid in the moment? Can he just make it and tell them that he doesn't want to go to the hospital? And, you know, they have to, you know, basically honor the patient's wishes, not necessarily the family member's wishes. So unless there's some court order saying that he's incompetent or that there's a guardianship established for him, then they're probably going to have to take the patient's word for, you know, the patient's directions in terms of what they can and can't do. You know, it's obviously a difficult situation for the care providers, difficult situation for the family members. You know, if you do have a health care power of attorney that allows you to make all health care decisions for the patient, that's something that could potentially trump the ability of the patient to, you know, tell the folks that he doesn't want to go to the hospital. But that's really kind of a complicated legal, you know, situation that, you know, EMTs are going to have to deal with on the fly. So it's really a difficult situation. But if this is a recurring thing and he's not able to make decisions for himself because he's not competent, then you can go to court, be appointed the guardian, and then you get to make the decisions.
Probably an estate planning lawyer could help her.
Yeah, or somebody that handles probate, you know, any types of things like that.
Good luck, Teresa. Melissa's on the line with a question from Harvest. Hi, Melissa. Thanks for calling. What's your question tonight?
Thank you for having me on.
Sure.
So I had a gentleman that was our roommate for like 2.5 years, and he passed away in August.
Okay.
And he had a drivable camper that was left in my yard. And he has a daughter, and she lives in the state of Tennessee. She said she was going to come get it, and then she's changed her mind. I gave them 30-day notice to get it. She changed her mind and said, you can have it and do whatever. I asked for the title. She refuses to give me any more contact information to get the title from her. What can I do with the camper?
You know, if it's a vehicle, or if it's a you know, property that has a license and a registration, and in Alabama there's a statute that allows you to get ownership of an abandoned vehicle or abandoned property that is on your property. So you basically you know, have to file with the state, and you have to prove that you provided notice to the owner or the potential owner of the property, and then, you know, once it's been there, and I think the time frame is 30 days. If it's been there for 30 days and you can prove that notice, then you can have the abandoned property retitled in your name.
We've got Don on the line with a question from Fayetteville, Tennessee. Hi, Don. John? Was it John? Hi. Don. D-O-N. Hi, Don. Thanks for calling from Fayetteville, Tennessee. What's your question tonight?
Yes, my wife has a rental house.
Okay.
And the people living there put in a above-the-ground pool.
Okay.
And then the city came out and said, well, y'all going to have to put a fence up. And what is the requirements on that?
And he's in Tennessee.
He's in Tennessee, so it's probably a little bit different than Alabama. You know, city ordinances are you know, most likely the same, but every place would have a little bit different in terms of their city ordinance and their requirements. But you know, a lot of ordinances or a lot of city ordinances say if you do have a pool, you have to have a fence that's in place. You know, obviously that's something that I don't think would be your responsibility if they've decided to put an above ground pool in. I don't know what your specific lease agreement says about whether an above ground pool could be installed on your property or not, or whether you think that's a good idea. You certainly could would have the ability to control that because it is your property. So, I mean, you know, I would say that there would, you know, if they're going to do it, then they have an obligation to put the fence up and comply with the city ordinance. If they don't do it and then you know about it, then you could be potentially responsible for problems associated with the pool because they don't have a fence.
Good luck with it, John. And we've got Mark on the line with a question from Fort Payne. Hi, Mark. Thanks for calling. What's your question tonight?
My question is, if you're driving along a residential area, a lot of these older historical homes and apartment complexes and townhomes, some of them don't have driveways, and some of these people park on the main road, and some people, although there are driveways, they park on the main road anyway, and you're driving along, and you accidentally hit one of them, the vehicles, whose fault would it be?
Well, I mean, you first look to see whether the vehicles were on the side of the road, if they're lawfully parked, you know. You can park on the side of the road in the direction of traffic that you're traveling, unless the vehicle, unless there's, you know, a no parking sign, or unless the curbs are marked so that you are not able to park there, or unless there's some ordinance that controls where you can or can't park. You know, if you're driving down the road and you hit a vehicle that's lawfully parked, it's going to be your fault. If you drive down the road and you hit a vehicle that's illegally parked, that's going to be a little bit different situation, and more than likely, at minimum, there's going to be a question about whether it's your fault. But you know, you really want to look at, you know, are these vehicles legally parked? Are there no parking signs? Is there ordinance or something, or some striping or some notification that indicates they cannot park there? If they can't, then, you know, then they're potentially responsible for the damage.
Good luck with it, Mark. Okay, we had an email question come in. I think I need to talk to a lawyer about my back injury. I've never done this before, and I don't know where to start. What happens when I call somebody? Is there a meeting? Do I pay up front? And that's from Carlos.
Yeah, I mean, it varies. You know, when I started doing this about 30 years ago, it was you know, every lawyer that I knew sat down and talked with a client and met with them face to face, talked about their situation, gave them some advice, and they decided whether it was something, a situation where the client could, you know, would want to be, or the injured person would want to be a client. You know, in this world, it's a lot different. You got everybody that's advertising. Their lawyers aren't meeting with clients. Lawyers are settling cases and they've never seen a client. Lawyers have case managers or intake specialists that run out to people's house and get them to sign paperwork without giving them any legal advice, or they can't lawfully give them any legal advice. So it's just a crazy world that we live in. But in my practice, what we do is I talk to each client on the phone. We set an appointment. I talk to them face to face. We sit down and talk about the facts and circumstances. And if I take on the case, I'm going to be the one that's going to be involved in that case. I think that's a better way, and I think that's a good way to make your clients happy and get the results you want for them.
And do you charge for that meeting?
Oh no, we don't charge initial consultations. We charge a contingency fee. We get paid when we collect.
And that's typical for personal injury attorneys.
Yeah, most lawyers do that same thing.
Okay, let's take a break. Be right back answering more of your questions on Ask Us Anything Night. If you didn't get your questions answered tonight, here's how to get in touch with Michael Timberlake with Timberlake & League in Huntsville. 256-536-0770 or 800-804-2502. The website is law-injury.com. And if you like them on Facebook, you can learn more about the law that way. And I do family law, divorce, child custody in Huntsville. 256-539-7337, SharonFamilyLaw.com. We had an email question from somebody asking if I co-sign with my boyfriend on his truck loan, does that make me responsible if he misses a payment or has a wreck? Ooh, careful.
It makes you responsible for the payments on the wreck, on the car for sure, regardless of whether he's paid, how much he's paid, or whatever. You're still, you know, fully responsible for the full note. You could potentially be responsible as the owner of the vehicle if your boyfriend was not reliable and he had a wreck.
Have a great week.